This computer. So, welcome back, everybody. Now we're already on week 2, which is wild. And we're here with Dr. Harrington again for another amazing session. And I don't need to talk anymore. I'll let her take it away.
Oh, Shannon, I think you can always talk. We always get more from you. Anyway, thank you. Oh, God, there I am on a big screen. Lovely to see you all. Welcome again. I finally realized that at least on my view, my screen is inverted, so it looks backwards. Anyway, whatever. Yeah, Jimenez telling me, yeah, it is. Technology. I'm old. Anyway. Welcome. I hope you all had a good and restful weekend, and Eid Mubarak to those of you who have been celebrating. Um, and thank you, Jimena, for the comforting news that we all see it that way. Thank you. So let me share my screen, and we will have our PowerPoint presentation, which again will be available. So, please do feel free to take a look at that. And also my email, as we had been talking before everything started to be recorded, about my email and accessibility. So my email is also on here as well. And please do feel free to be in touch by email or by LinkedIn or any other way. I'm happy to WhatsApp. I'm happy to to chat at any point, and not just now, but also into the future. So, after this course, I do hope that many of you will stay in touch, and certainly for those of you who will be at INC, we need to organize meetings. We need to organize ways of getting together, or just getting coffees, or actual proper food too. But getting a group going and making sure that we stay in touch. Um, so now the administrative elements are done. So this week we will be starting a bit more of the concrete ideas of international environmental law. Last week you will all recall, or hopefully you will recall, although I know it was a lot, so you may recall only a little bit, that we talked about the idea of what international law is, and also what treaties are, and the essential elements of treaties. So what we're going to start doing now is moving into the idea of what international environmental law is. In this session, we will talk about that, and we will then talk about some examples of the really critical, already existing pieces of international environmental law. Um, this will necessarily be kind of a broad overview, and we could do a session on each one. So it will be really just to introduce you to the very basic idea of what each of these does and what they regulate. And then when we get to our Thursday discussion, we'll talk more about how all of these, what we call multilateral environmental agreements, or MEAs, how they all come together, how they work together, and what happens when there may be areas where they both work in the same area. How does that get navigated? Um, so that you can understand a bit of some of the really important questions that are coming up more and more when we see that environmental law is being created internationally at a much bigger scale than it was initially. And we do see areas where there is the potential for overlap, because it's not the end of the world, but we certainly do need to kind of understand where it comes from and what happens. And also on Thursday, we'll talk about what happens with other aspects of overlap between international environmental law and, say, trade law or human rights law, etc. So we'll get to that, but we'll get to that on Thursday. For now, we will get to our discussion of, first of all, what the learning objectives are. Um, so basically, we will address the history of international environmental law, and the concept of multilateral environmental agreements, or MEAs, which I
Alex,
see the
sorry to
transcription on.
interrupt you very fast.
Yeah.
Is that we're seeing your presentation not in like full mode? It's like
Oh,
on, so I don't know
oh,
if you
okay.
try maybe to,
Yes. Let me try to do this.
yes,
How do
that's
is
perfect.
that better?
Yes.
Okay,
Thank
excellent.
you.
Thank you, Hannah. Always tell me technical things, please. Always. All right. Let's see. So we'll talk about existing MEAs, as I mentioned, and then later on we'll talk about the MEAs and the nexuses. So um, this is what we're in for this week. Many of the photos that you will see are photos of lovely destinations where some of you may be or some of you may have been, but they illustrate the cities where we find international law to have been created in the sense that we find a number of different agreements throughout international environmental law and other international law, generally named after places. So when we see things like the Stockholm Declaration, this is a photo of one of many of the lovely city of Stockholm. And just to explain, because there are sometimes questions about this, why are things called various names? They're called various names because this is typically where they are ultimately signed. So a process in international law may begin in one city. It may begin in New York. It may begin in Nairobi. It may begin in, say, one of the UN headquarters cities, and then have multiple negotiating rounds, like the Plastics Treaty. But typically, if it's going to be named after a place, it is fairly or unfairly named after the place where it is actually agreed to, where it's signed, where the major diplomatic step towards agreeing and implementing it has been taken. So this is a background I often like to explain to students because, and to those who are not familiar, because it can be a bit confusing. So Stockholm, our lovely city of Stockholm here, gave rise in 1972 to the Stockholm Declaration. And the Stockholm Declaration itself is a huge accomplishment in international law and international practice, because it was the first articulation of principles for what international environmental law, which we abbreviate as IEL, might look like or did look like at the time. At least this is what I'm told. I was not alive, but I was told that this is what happened. So we're taking the words of our elders here. Anyway, as we learned last week, the idea of a declaration, the idea of a guideline, or anything like that is not legally binding. So, what happened in Stockholm in 1972 was that the global community of states came together and they adopted a declaration of principles that are not legally binding, but they are soft law. And they have become very important. They have become very important as the guiding elements for the next wave of principles that we'll talk about coming out of Rio, and then also for a number of different treaties. And when we think about kind of looking into the history of international environmental law, where did it come from? If you, any of you are, for example, students doing research and you want to look at these types of questions, you want to go back to this point in time. Um, because international environmental law to all of us, and to especially many of you who are younger, will seem like something that's always been there. You assume it's always been there. It's part of our international law practice, and the idea of not having, say, a COP every year, a conference of the party every year for the UN Framework Convention on Climate Change would be very alien to many people. But the idea in international law of actually recognizing environmental law and having it as a separate field is something that is still relatively new. In 1972, whilst it might seem far away now, is actually in international law history relatively recent, relatively new. And so, what we understand here is that this is a big step in 1972. International law, generally, up until this point, had been an evolution from really well established rules of practice that didn't necessarily even require a treaty. So, things like the inviolability, so the safety, the protection of consulates, of embassies, and of ambassadors and diplomatic staff. These are things that date back centuries, if not millennia. And they have always been kind of part of the way that international law, such as it has been called over time, has been practiced. Similarly, international, what we would now call law, but might not have been called that at the time, agreements between various countries, various kingdoms, various sub-entities that were ruling themselves for trade was very commonplace, very common practice, from certainly biblical times onwards, and has continued on. And we saw it coming out of World War One and then World War Two, the idea of an evolution into modern international law, where we have a lot of international organization focus and an effort to use international law to stop war, to promote peace, etc. But what we didn't see until 1972 was the idea of using it to address the environment. So everything happened really quickly in a way from this point onwards. And so we went from the lovely city of Stockholm to several key elements in the declaration. And the key elements here include, there are a number of them, but they include things that you will hear referenced again soon. So things like the obligations of mankind, and at the time the language was mankind. Um, Many of you will know it has been switched over to largely humankind or people kind, but time mankind, towards Earth and many aspects of environmental resources. So not just resources we can exploit, not just things in the ground, but also things like forest, things like wetlands, oceans, etc. We also saw elements that included the principle or the idea of preventing multiple forms of pollution. So, recognizing that a good deal of environmental damage was being done by people, by individuals and societies. And so, trying to stop that. And at that time, it really was a much more of a pollution recognition issue. Also, 1972 is where we first see in this declaration the articulation of the idea of the rights of future generations and the concomitant responsibility and need to have certain aspects of sustainable development start to come into what states do and also what the international community does. And finally, we saw a very critical connection that we'll keep coming back to and that keeps being affirmed and reaffirmed in different ways over time in terms of the connections between human rights and environmental protection. We all assume this now. We all know this now to be a matter of both common sense and practice, but also international law and certainly international relations and politics, etc. But at the time in 1972, this was really new. This was a really new way of looking at things that had been kept very separate up until this point. So these are all critical elements coming out of Stockholm. We then see that actually, even before this, in 1971, there was a treaty concluded, which in many ways um, laid the initial foundation for some of the principles we saw in the Stockholm Declaration and has subsequently come to be very much emblematic of the Stockholm Declaration era in terms of the way we think about regulation of the environment, and that is the Ramsar Convention on Wetlands. So here, I do not know where it is from. It is, however, a wetland. So just to give you an idea what we're talking about with wetland protections, the Ramsar Convention, which is named after the city of Ramsar in Iran, creates obligations for state parties regarding the need to protect wetlands that are recognized as such within their jurisdiction. And it also, as a fundamental element, recognizes the importance of wetlands, not only in and of themselves and for the species that are present and the biodiversity that is present, but also for the overall environmental health of both nations and states, but also the international community. So it really does focus a great deal on wetlands for recognition in a way that many of us don't really even think about necessarily in our daily lives, but recognizes that they're there and is still very much active today as a treaty regime. And finally, and again, this is a longer process, but it creates a way of designating and listing um, qualifying areas that are wetlands so that they are listed nationally and recognized internationally as being protected with consequences for what various countries have to do in their own national legal regimes to protect those particular wetlands, as well as international oversight, allowing the international community to look at, to monitor, to engage with protected and designated wetlands on the idea of trying to balance between the sovereign right over wetlands and over territory in their jurisdiction and international interest in maintaining that as a safe and sustainable preserved area because of its inherent environmental value. So this is something that's very much still in place. It's very much going on now. The Ramsar Convention is a very active entity. And actually, as we were talking about being in Switzerland for INC 5.2, it is also headquartered in Switzerland. So it is something that continues on, but it was one of the first really recognized international treaties relating to the environment. Next up, and I chose a rhino because I thought they were emblematic of species that are heavily under threat here. Um, in 1975 was the signing of the Convention on International Trade in Endangered Species of Wild Fauna and Flora, which we all abbreviate as CITES, not to be confused with cities, as many spell checks will try to do. So if you are writing a paper, please, I see the whole time, just make sure that it's properly designated. Anyway, the CITES regime is still very much active. It has grown a great deal since 1975. But what we should point it out for, there's several things, but one thing to point out for that we'll come back to when we get to Thursday is that it is one of the first efforts to really bridge sectors of international law. So we see that it is very much an environmental treaty, and this is a new and emerging area in 1975. But we also see there's an effort to bridge, to connect the environmental law aspects that are being created internationally with trade and with regulation of trade. It is a very limited form of trade, so trade in endangered species. And it certainly has a very limited application, but it's still one of the first efforts to have environment linked to trade and recognize that you can regulate both. A shocking concept. At least it was at the time. It certainly isn't now. It creates both national and also international requirements. So, national requirements for state parties, and then international requirements also for state parties, as well as for the organization, the Conference of the Parties, and a very intricate system of committees that are used to address different types of threats and different types of trade and concerns, et cetera. So it creates international and national requirements for protection of traded species. So species that are actually legitimately traded across the borders, and also for existing fauna and flora, which is a very fancy way of saying biodiversity and wildlife in states that receive traded species as well as states that export. It has created a very sophisticated system for how we designate what is an endangered species, and often links to the, I should put this in as a plug, the IUCN, the International Union of Conservation of Nature, has a red list. So the red list designation of species that are either critically endangered, endangered, at risk of becoming endangered, et cetera, and then requires that regulations be put in place by states and the international community to address trade in these species, including potentially banning or severely curtailing that type of trade if it is considered that the species may be indeed at risk of extinction at a very grave level. It also increasingly, I should point out, has come to work on issues of trafficking. So on animal trafficking, on species trafficking generally, we all think of rhinos, of tigers, of more endearing wildlife that is cute to look at or appealing to look at. But we should also remember that this type of trade includes things like plants. It includes things like trees, timber, etc. Any type of wildlife and wild resource that is endangered in some way. Not only animal life, it also includes fish, etc. So it is quite wide ranging. So this is from 1975, and it has been vastly developed since that point. We had a long period of time of reflection. We had many other things happen. We did have the evolution of the ozone layer as a particular area of focus for international environmental law, and the depletion of the ozone layer in particular as being a very prescient threat in international law. And then we got to 1992. And 1992 was a huge year for international environmental law. I cannot lie. I don't really remember that at the time. I was kind of too young to remember it, but it was. And so in 1992, we had the Declaration of the Rio Principles and also the Rio Declaration itself. And as we will talk about in a few slides, the creation of three very emblematic treaty regimes that have come to kind of explain many of our concepts of how we think of international environmental law, certainly up until today. But the principles first from the lovely city of Rio are 27. We will not go through all 27, but I will highlight some that are really critical, not only because they explain the status of soft law at the time, but also because they have become part of many subsequent treaty regimes. So, to show you how soft law can then be taken and put into treaties, I really want you to see this. And then also because they have been the basis for various court decisions, including major decisions of the International Court of Justice, which has actually managed to incorporate a number of the Rio Principles into critical holdings for over 30 years now regarding how we think about international environmental law, how we think about regulation, and also what the obligations of states are to not only their own citizens, but also to each other and especially to their neighboring states in terms of potential environmental law damage. So, or environmental damage under international environmental law. So these really are quite critical principles. And when we get into the plastics treaty context, you'll see many arguments about what these mean even today and what we should be applying even today, although they are now much older. So, what are some of these principles? The first principle, principle one, is the recognition of the human need for sustainable development. And this is something that we'll come back to a great deal when we come back to discussions of debates in the plastics treaty context, um, and also other aspects of international environmental law about how we balance human rights, human needs, recognized rights in international law, and whether development should be given a status higher than, for example, the right to life, et cetera. There are some legal systems in which this is the case. There are some in which it isn't. But regardless, the basis for the recognition of at least a human need, if not actually a right, for sustainable development comes to us from the Rio Principles. It's always good to know where something comes from, even if we're still arguing about it today. The next principle, principle two, again, is something that we see coming in now as a question of how much primacy, how much weight do we give it in creating new treaty regimes. So this is the idea that even if we're talking about international environmental law or international law, we're still acknowledging that states have sovereignty, so they have control when they're recognized as states over their natural resources. So over the natural resources that are within their territory. So anything from biodiversity, wildlife, various types of ecosystems, to also things that can be exploited. And in this concept of when we say exploitation in the natural resources context, we're referring to actually removing from the ground or removing in terms of clearing forests, et cetera. It doesn't necessarily have the negative connotation that we talk about if we talk about, for example, exploitation of child labor. So just to know that there is a nuance in the way we talk about it in natural resources. But Principle 2, to get back to Principle 2, points out that and highlights that states have sovereignty over their natural resources, which means they have the ability to control them and the ultimate ability to speak for how they will be used. So giving state more power in a way, on the one hand. But then on the other hand, points out that states also have a responsibility uh, to ensure that their activities or activities within their jurisdiction or within territory under their control do not cause damage to the environment of other states or of areas beyond their territorial jurisdiction. And this actually also will be something we see later on when we mention in the future discussions the Biodiversity Beyond National Jurisdiction Agreement, which was just signed in 2023 as well. So this is an idea that keeps coming up. And it's an idea that's formed the basis of many different court cases as well, especially at the International Court of Justice level. So we move on from some lovely scenes of Rio to now I wanted to do a forest scene. So we don't neglect our forest resources. What else do we have in these principles? There is, again, an articulation under Principle 3 of what we would now call sustainable development. So the language of the need for development to, quote, equitably meet developmental and environmental needs of present and future generations. This gets to sustainable development. It also gets to the idea of intergenerational equity, which again is highly linked to concepts of sustainable development and basically seeks to ensure that whatever resources are used by us, by current generations, are used in a way that they don't cause damage to or they don't cause future poverty of resources or resource access issues for a future generation. So it's the idea of having a balance between what we know now in the present and what we anticipate in the future. There are some communities, especially many indigenous communities, that use ideas of multiple generations. So ideas, for example, from the North American indigenous community context often focuses on 7 generations. So trying to protect whenever we exploit something that is a natural resource, trying to do so in a way that we protect the next 7 generations. There are a number of different legal traditions about this as well. But the principle that we see here really is the idea of sustainable development and also intergenerational equity. Um, we see here in Principle 5 the idea of the need to have development that addresses poverty, so that doesn't just advance certain interests, but advances everyone. And also that recognizes the special situation of developing states, especially least developed countries. We will come back to Principle 7, the principle of common but differentiated responsibilities, a great deal. So when we talk about the UN Framework Convention on Climate Change, when we talk about the Plastics Treaty, we will talk about this a great deal more. In essence, what this was articulated as at the time and what it has come to really mean to many people is the idea that all countries have some type of responsibility toward protecting the environment, whether it is in the context of climate change, whether it is in the context of pollution and plastics or other forms of pollution, but that those responsibilities may be differentiated, maybe a higher level or a lower level, depending on the overall responsibility that that particular country has played in creating the problem. So, for example, a country that never uh, used a great deal of coal energy, that never was responsible for the creation of a great deal of emissions of carbon and carbon dioxide into the atmosphere, um, will often argue that it, under the principle of common but differentiated responsibilities, it has a lower threshold responsibility for creating the problem. And so the financial burdens, the technical burdens, et cetera, that are placed on the global community under international law to address climate change relating to carbon should be lower for that particular country because it wasn't one of the entities that created the problem. So this is where we see this first articulation. Principle 10 gets into access to information at all levels relating to environmental concerns. So here we think about access for individuals. We think about access for many of you who are working in the civil society sector. This is one of the main sources of support for creating the space that we have in international law practice for civil society to be present. It also has gone on to underlie things like the Aarhus Convention, which is the first real recognition, treaty recognition of the right to access, the right to information, etc., which comes to us from the from the European and then into Eastern European and Central Asian contexts. And then also the very recent Escazú Agreement, which is a very similar agreement for Latin America and the Caribbean, and also includes environmental defenders. And I am seeing the transcription on the bottom, and I'm very amused at how some of the transcription is picking up. Escazú, for example, is highly entertaining. Anyway, um, other principles we have here, the reiterating that states actually need to adopt comprehensive environmental laws and practices and standards, especially those that relate to, at the time, assisting those who were impacted by pollution. Again, this is a really delicate balance, even for soft law, because it's trying to say that, again, states are sovereign and maintain their sovereignty, but also say that states need to and should do something, which is to change their laws to reflect environmental policies and needs. So it's a delicate approach. Principle 15 is the precautionary principle. And this is something that keeps coming up. It will come up again in nearly every treaty regime afterwards. And it addresses the idea that when states are taking action or not taking action, or deciding, for example, on environmental impact assessment, and whether it should be granted or not, or what types of limits should be put on a project, they need to act on the idea of precaution, and they need to act in a way that errs on the side of trying to be protective against potential future calamity, whether that's an oil spill, whether that's a toxic spill from the construction of a the manufacturing plant, for example, whether it's the construction of a dam, all of these things and many, many others go into the idea of the precautionary principle. The correlated polluter pays principle, for principle 16, places a different type of obligation on the private sector and also on countries themselves to make sure that there are laws in place and that they are applied thoroughly so that the polluter, whoever that person is under the greatest obligation to pay for pollution and its associated damage, rather than placing that burden on, say, the entirety of a tax-paying base or a community that may have the burden of trying to clean up after an oil spill on their in their jurisdiction on a lake, for example, or a river that comes into their jurisdiction. This is also the basis for what we are arguing about in the plastics treaty, and we'll come back to, which is the idea of extended producer responsibility and how we might think about putting that in place in international law. So it lays a really important foundation. Um, I referenced environmental impacts a while ago, and well, really like a minute ago. And the requirement for national use of environmental impact assessments actually comes to us from Principle 17. along with aspects of notice and notification requirements, both nationally and internationally, under Principles 18 and 19. And so together, this whole package means that states committed as a soft law instrument, which has then thus become hard law both through case law and then also through treaty law, to adopt environmental impact assessment procedures for a number of different types of projects and government projects as well as private sector projects or combinations thereof. And to look at not only what the impact would be at a community level, but also what the impact would be at the national level and the international level, especially on states that are neighbors or that share transboundary resources. And we've seen a number of instances where this becomes quite critical. We actually saw this in what we all affectionately know as the dams, the Hungarian dams case. I will not attempt to butcher the names of the parties in either Hungarian or Czech, but coming to us, kind of fell in laughs, but you know this is true. Coming to us from the International Court of Justice, we're now, I believe, 32 years ago, the International Court of Justice recognized that there is indeed an obligation on states to take into account the transboundary impacts of their planning processes and of proposed projects when they are looking into them in the environmental impact assessment context. So this is the core of where it comes from in terms of an obligation. And finally, to highlight a few things that are really important for many of us on this call, especially for CYMG. The Rio principles articulate things like the role of women in protecting the environment and also advancing development under Principle 20. And Principle 21, I highlight this especially for you, Shellen, is the role of youth as a major actor now and in the future in promoting and protecting environment and environmental interests. So your obligations started here and have moved on, and you have all met them really well, but this is one of the places that they're coming from. And also a special recognition in Principle 22 of the role of Indigenous communities and local communities. And we see this again and again coming up after this point as, first of all, something that is very much in the preamble of many initial treaties. And then subsequently, that something that has become much more of a mainstream actual provision in various elements of treaties that have been adopted recently and also that are being proposed for the future. So there are a number of different principles that we owe a great deal of subsequent international law to, which is why I've spent so much time on it. But when we then move forward, 1992 also gave us three very important MEAs, two of which many of you likely have heard of. One is like the Cinderella of our story, right? Where, she's always like the one that no one thinks of anyway. Sadly, we have that one. So we have the UN Framework Convention on Climate Change, which most of you know, which was adopted as a framework in 1992. Now, this obviously has gone on, and it has a great deal more focused areas and topics, first of all, in the Kyoto Protocol, which was adopted in 1997, although it didn't become actually effective until the early 2000s, and largely expired in 2012. It was replaced partially and then fully, as of several years ago, by the Paris Agreement, which was also adopted in the framework of the UN Convention on Climate Change, but that still is a separate agreement as well. So that is one package. We have the Convention on Biological Diversity, which is another package. And I say package because it was adopted in 1992, but it also has subsequently had two different protocols, one on access and benefit sharing, and the other on prior informed consent, so transportation and trading of various types of biological diversity, and the prior informed consent that needs to be given by states of export and import before that can actually happen. So that's another package. And the third Cinderella of our story, before she turns into the Belle of the Ball, is the UN Convention on Desertification, which is a much smaller treaty. It's still critical, which is why you have the lovely image of the desert to remind you that it is quite important. But it is a much more niche treaty area. It is much more reflective of a topic that at the time was thought to be very important, but has come to occupy a great deal less visibility in international environmental law. It is still important, though, to know that that particular treaty is out there, and it is continuing to operate up until the current day. And then we also moved on to a number of different MEAs that have been adopted in the context of more pollution and more specific aspects of pollution than on general environmental concerns and environmental law treaty focus, which we think of when we think of the Framework Convention on Climate Change, when we think of CBD, the Convention on Biological Diversity, et cetera. So we have first the grouping, the triple grouping of what we call colloquially the BRS conventions. These are actually three separate conventions. So there are three separate conventions adopted at separate conferences of the parties or at separate negotiating processes. They create three separate conferences of the parties, but because they are all interlinked and because they share so much of an overlap, the decision was actually made to combine them and to combine their secretariats. So we have one unified secretariat that has all the operational functions for all three treaties. And actually, they have actually, interestingly, coordinated their conferences of the parties. So they meet every 2 years at the same time over 2 weeks. They're actually meeting at the end, well, mid to end of April into early May, in Geneva and this year, and they meet every 2 years. They meet sometimes in joint session, so they have many similar terms, especially in the beginning, in the opening parts of the treaties. So they meet in joint session for those types of matters. And then they meet over the course of the 2 weeks, kind of on a rotating basis to address issues that come up under each of the separate conventions themselves. What do these conventions regulate? The Basel Convention, which was the first, also from 1992, regulates hazardous wastes and seeks to do things like create annexes, create lists of hazardous wastes that are either banned or significantly restricted in use in the international law realm. The Rotterdam Convention, which is by far the longest name, and hopefully by now you're seeing why we have so many acronyms in international law, because we have so many treaties that are such long names. It's very difficult to actually say them all and then remember what your point was. So in 1998, we have the Rotterdam Convention on the prior informed consent procedure for certain hazardous chemicals and pesticides in international trade. Rotterdam Convention, which is an interesting combination again of how we think about environment and pollution and trade regulation. And then we also have from 2004 the much shorter named Stockholm Convention on Persistent Organic Pollutants, also known as POPs. Again, seeking to create through annexes that can be updated and amended as needed, designations of things that are considered to be either so dangerous they need to be banned or severely restricted or have certain types of reporting requirements imposed upon them at national and international levels when they are classified as certain forms of persistent organic pollutants. So that is the package together. One other very new one, and because it is new, I wanted to do something fun. So here you go for all of you who are chemistry fans or chemists or just science fans generally. Here's your quiz. What is Hg on the periodic table? It is mercury. Now, many of you might not be as familiar with this image of liquid mercury. Growing up, I still recall when I was quite young the use of a mercury thermometer. And I do remember when one broke once and then beat it up all over the floor, and it was a mad rush to stop the dogs from eating the mercury. Anyway, For those of you who might not remember that, mercury had many other uses before its full toxic nature to humans was understood. And it still does have some uses now in extractive processes, especially those relating to gold, for example, and even in dentistry across a number of different countries. So in 2017, we saw the adoption of the Minamata Convention on Mercury, which is an effort to severely restrict and ban, in some instances, the use of mercury across a number of different areas. Also to provide assistance to especially uh, women, indigenous communities, impoverished communities that have been heavily exposed to mercury. And actually, as an interesting fact, the Minamata Convention itself, the city of Minamata, in Japan was chosen as the site for the signing of the convention and the name that it would have because one of the most important scientific studies of impacts of mercury and mercury poisoning came to us actually from the city of Minamata. And those of you who have a science background or a medical background will probably know about this. This was an area that was subject to extreme exposure to mercury and its effects. And so we have a number of different generations impacted by it. That is why we have the Minamata designation there. So that is actually the end. I can't believe I ended early, but I really wanted to make sure we got through everything of my presentation on the MEA process. I didn't want to do a ton of greater information because it is overwhelming. I know it is overwhelming, and there are so many names coming at you. So I will happily stop sharing the screen and then we can take questions. But as you think about this more, if there are treaty regimes that I mentioned that you think are really interesting and you want to know more about, we can certainly add that to our discussion next time as well. And either just let us know yeah, or raise it in the actual session on Thursday, or if you want to send us a message or me or Shellen and let me know, we can certainly talk about that. Um, and I'm looking at some of the comments here. Yes, so someone in the comments had pointed out about Minamata disease. Yes, exactly. So thank you, Jimena. Jimena, I should just defer to you because you are the medical doctor here. So, I should just defer to you about these things. And if you want to jump in at any point, please do. So, Ellen, I hand over to you. Questions,
Yes.
comments,
I just
anything?
gotta say, I feel like today I'll put myself in a little bit annoying pin view, speaker view, have to the spotlight, even though we don't want to be in the spotlight.
Please take the spotlight off me.
Well, us together, I guess, since we're doing the questions, but I just gotta say, I feel like today was a reminder of why we're doing what we're doing. You hear all these Rio, Minamata, um, intergenerational equity, polluters pay principle, and they refer back to these treaties and like, what the heck are these treaties? So I feel like, and of course, they don't teach you this in school, but they should.
And this is what we were going for. This is what I was going for. Absolutely. Mhm.
Yes. So question time. I see there's questions. I gotta get up see here, the questions. Yes, there will be a recording, of course, and I will try to put it on. So let me find, or Jimena, I'm sorry to ask, can you send the questions
Yes.
again? Yeah, really is a very informative session as always. Let's see here.
Thank you. I saw one in particular that I'm curious to address. Can I just jump into that while we're
Thank you.
waiting? Oh, there we go. There's a document. Yep.
Okay, I'm also getting some. Okay, so here we go. Oh, it's April Fool's Day. Oh, wow. Okay.
Oh, it
So,
is. But I promise you, everything in this presentation is entirely accurate. Okay. There is no joke. There's nothing else. I promise. It
okay,
is
so,
April Fool's Day, though.
yeah, time flies when you're having fun. Okay, so there's actually a question from the previous lesson. We'll start off with that. Which is the force that regulates a treaty? Is it the VCLT?
The treaty itself will regulate, like, they will designate things like whether or not a state can withdraw, how much time a state would need to withdraw, whether it's a year, 3 years, and basic procedures. If there's a question, if there's a gap, if the treaty is silent on whether a state can withdraw, and there was no discussion during any of the negotiating sessions. There were no proposals that were left out. It was just completely silent. Then you would use the Vienna Convention as a gap filler. So you only really bring in the Vienna Convention if there's a gap, if there's a question and an uncertainty, and then you can use it as an interpretive guide. You do, however, have to be careful that the treaty itself, so you're looking to interpret, either makes reference to the Vienna Convention and says this can be used explicitly, or that it doesn't say something like the Vienna Convention will not be used as a guide in this particular instance. So you do have to check the treaty text first, but generally that's where you would use the VCLT.
Great, great. Next question. How are transboundary environmental issues, especially particularly pollution like air pollution, ruled legally? Would that be a combination of ruling within the jurisdiction, sovereignty, or and beyond the
Mhm.
jurisdiction outside sovereignty?
So it is a combination. So what we have, for example, for air pollution, we have the Vienna Convention and the Montreal Protocol. Now, the Montreal Protocol really looks um, at ozone uh, depletion. So at the time, it was a very important issue. It's obviously been fixed a great deal more, which is why we think of it as a very successful treaty. One of the rare instances where everyone agrees it's a successful treaty that we've tried to replicate, and we never actually can. But anyway, in that instance, we have air pollution as a particular regulation, both creating under the treaty system obligations for all states to follow at home, and then obligations towards their neighbors, towards their uh, either border sharing states or states which would have transboundary impact, which doesn't have to necessarily be a neighboring state immediately next door. It can be a state several states over that will still be within a trajectory to receive pollution, et cetera. We also have treaties that look at this in terms of now biodiversity beyond national jurisdiction. We have it in terms of pollution in many of the regional seas conventions as well, and certain aspects of, for example, the UN Convention on the Law of the Sea. So UN CLOS has various types of transboundary issues that go across jurisdiction. The pollution aspects themselves, the BRS conventions do have some more limited elements of transboundary liability and requirements, um, as well as national. Minamata tends not to focus on that, tends to be focused more on national implementation. So it does depend on the treaty regime, but we do have examples for transboundary. And we also have a number of transboundary, I should point out, regional treaties. So many of the regions have realized that there are more shared types of concerns over different types of pollution. If we're talking about air pollution, it might be certain types of chemicals in the air, et cetera, that are within a particular region. So they have created also their own regional governing bodies on this, which is a whole other topic that we could talk about for future, shall we?
Oh yes, oh yes, and still have I mean, so many questions today. I think just youth also could speak for in the negotiations. You hear all these all the time. For example, Ghana is a big promotion of the polluter pay principle,
Yeah.
but little did we know until today it comes from the Rio Declaration.
This is why we do the history. Sometimes it's important, sometimes it's helpful. It's not
S-
always the thing that puts you to sleep.
Speaking of Rio Declaration, aren't there a principle 12 within the Rio Declaration and principles? I think you said you only really covered the important ones, not necessarily all of them, correct?
Yeah, I didn't cover all of them because
We
there are
could,
27.
we could.
We could easily do all 27. We definitely could. And if there are some that are on your greatest hits list that I didn't touch upon but you want to talk about, we can certainly add those in next time if you like. There is a principle 12. There are indeed a whole complement of 27. The major, and they all are important in their own way. It just that some have come to really embody things that then go on to be adopted in multiple treaty systems and that continue to be used now. And some are kind of very important, but very static. And so they haven't generated that same level of international law importance. But we certainly can go over 12 next time if you'd like. Absolutely.
I guess I can give a hint. We might do another iteration of this or boot camp in the fall potentially.
Yes, yes, we may.
Hint, hint for the future. Um, why is it called a framework?
So it is called a framework. It's a great question. It is called a framework because literally it lays like the framework, the foundation for future regulation. Um, so the UNFCCC, I'll use this as an example because it's like the principal example, was created in 1992. And again, at the time, we didn't really know a lot about climate science the way we think of it now. So the community of negotiators trying to regulate this realized there is a problem. We need to have international law on it. But we also scientifically know enough and could at the time agree on enough. I know this might sound strange now, but we could, to know that future science will tell us far more than we could possibly regulate at this point. So if we tried to regulate climate change in 1992 as just a treaty like the Minamata Convention on Mercury, it would be very difficult and very much outdated really quickly, and it would constantly need to be updated and amended. So rather than doing that, the Framework Convention model was used, and it created the Conference of the Parties. It created essentially a recognition by the states that are members that climate change is occurring, that it is a threat under international science and under international experience. It is a threat to international law and it needs to be regulated. And an agreement that there would be regulation of the greenhouse gases, so all identified greenhouse gases, in an order that was later developed by various members of the Conference of the Parties and various iterations of the Conference of the Parties. And there was also a secretariat created to help to actually bring everybody together to serve the administrative function, which is now run out of Bonn in Germany. But other than that, the actual terms, so the legally binding terms, what we call the control measures, are very few because the framework really was to set up a system that would then go on and regulate what would happen in the future and what the future protocols or agreements would look like. And when we see the use or the suggestion of a framework convention, as some people have actually suggested for the plastics treaty, so I wanted to make sure I reference this here as well. Um, the idea is that we recognize either because of scientific knowledge or technical knowledge or a difficulty in generating political will across a certain number of issues that we can't necessarily get a really specific treaty with a number of binding control measures. So what we do instead is to set up a system that will allow us to have at least an annual meeting or every meeting 2 years come together to meet with conference of the parties. And we create a structure that will allow us to continue to create future regulations. It's a very long answer, but that's what a framework convention is. It gives us a structure.
It's actually funny because now it's perfect leeway into the next question,
Oh,
which
good.
is
Excellent.
why not put, I think this is also a question that a lot of us ponder, especially being environmentalists as well. Why not put all the conventions in only one COP?
Oh, dear God. First of all, I mean, it might just break the planet. I mean, just the flights alone would be a nightmare. Um, first, all practical and joking elements aside, and that would be quite interesting. Um, each of the MEAs themselves is a separate document, it's a separate convention, and it has its own legal requirements. It has its own state parties. not every state is state to the same or state party to all the different conventions. So they all have their own governance systems. They all have their own ways of handling certain things. They all have their own rules of procedure. Many of them are similar, but many of them are also different. So if we wanted to have one global COP of everybody, and every convention, we would have to actually have a series of amendments to most of the conventions um, to pick one time. So let's say we wanted to do it next year. We would have to amend the BRS conventions, CITES, Minamata, CBD, desertification and drought, etc., to allow for a meeting that's in an off year because BRS, Minamata, CBD all meet, and desertification and drought all meet every 2 years. CITES meets every 3 years. So, and those are all treaty terms, so they would all have to be changed. So you'd have to create a harmonized system. If we didn't want to do this every year, then also the UNFCCC would have to be changed because they meet every year. Um, then we would have to figure out how to structure it. It would take at least probably conservatively 2 months to hold the COP because each of the treaties would have to meet on their own and have discussions on their own and then cycle through like the way we have for BRS. And what I could actually do, actually, if you'll forgive me going online during this, be like all the students I yell at in my own classes. Let me see if I can get the BRS schedule up. So
It's coming up. It's gonna the second half of the year. We're about to hit the ground running and not stop until December.
it's about to start, and it's about to start in April. Let me see if I can get
You mean
this
this month?
meeting. I mean this month because it is already April. Oh my God, it is already April. Yes, it is. Let's see where it's an if document. So just so you see kind of how it looks, just so you see how it's structured. And if I can't find it quickly, where is this scenario note? Here we go. All right. No, this is a tentative schedule of work. This is, yep. All right. So let me expand this and I will share my screen again. Now, this is three COPs, and this is three COPs that are all harmonized, and they're all harmonized so that they didn't have to change their meeting schedules, they didn't have to do anything else. Uh, this is what it would look like. This is what it will look like for me and for a number of other people in a few weeks. So, if you notice, we have many different things. Now, the gray areas are the areas of overlap, so areas where everybody comes together. And then we have all the different, because they are different legal regimes and they have different responsibilities and they regulate different things. We have all the different meetings at separate times. So anywhere where you see green is the Basel Convention. Anywhere where you see blue, and there is a second week, so we'll get there momentarily. So don't worry, Rotterdam really is meeting. That's Rotterdam. Anywhere you have orange, that will be Stockholm. So as you see, Rotterdam is much later into week two. This is a tentative schedule. And so what happens, take a lovely look, take a gander. What happens usually is that this is a lovely tentative schedule and things go awry and um, discussions go over, etc. So it gets to be a little bit messy. So this is three treaties. If we tried to coordinate, let's say 10, it would be multiple days and months, probably. And we also have to remember that the people who are negotiating, or because it's a conference of the parties, but it's really a negotiation in terms of new proposals, um, they are also going to be doing many of the same treaties. So they're responsible for representing their countries at multiple conferences of the parties and multiple treaties. Thus, if you're asking them to be all combined together, um, some people, some countries may have to skip being in certain meetings to attend others. And realistically, people would burn out very quickly. So just from a very practical perspective, it also would be a bit hard. And I saw the comment about the tabs. Yes, I have like a million tabs open. I know, I do. I have many, many documents. They're all fun. They're all either relating to plastics or biodiversity beyond national jurisdiction. So super fun reading, not really.
Feel like also could just share from personal experience, and you and I have talked about this. You get to the point just alone in the plastics treaty negotiations where coffee no longer works, and you're
Yes, there
like
is that point.
trying to find alternatives like Coca-Cola. So yes, I mean 2 months sounds fun. Like it'd be a big kind of fun party, but also would we be able to do it? That's the big question.
It would be a sleep deprived party with lots of caffeine, lots of chocolate. And the other thing to remember is obviously that people who are doing this also have other jobs and other aspects of their functions.
And their parents.
So, and they are parents, they are children, they are spouses, they are partners, they have all of these obligations. And this is where I think it's also important to kind of to highlight, and again, because Charlotte and I have been like, in these types of negotiations and served as negotiators, that it is a very like international law, high level process, but it's run at the end of the day by people, as is any other legislative process. And people also have personal responsibilities and needs, etc. So keeping us all from like one massive global COP would be difficult.
It would be fun though. But yes, I get it. Let's see it. I'm sure hopefully that makes sense. So another question is because there's a lot of conversation about these different treaties have
Yep.
really purposes. And so here's an example of like who would take responsibility for the oil spills that occur when there's plane crashes or spills in the ocean, for example.
Um, so let's go from a plane crash. That is an excellent question.
And is
So
there a treaty for that?
there are treaties that relate to forms of pollution from air activities, but typically it's not in a crash situation. Usually the crash situation is covered by treaties that come out of the ICAO, which is the International Civil Aviation Organization. They tend not to be environmental. They tend not to really look at the environmental impacts as much. So what, thank you, Hina. Thank you for putting that in there. So what typically would be kind of, if there is a discussion about who would handle that, it would be between the state where the airline had crashed, and the state that is responsible, if there is one, for the particular airline. So as we know, or as many people know, when you fly, it's very much like when you're on a ship. The plane that you're on is flagged or registered to a particular country. So typically, unlike the interesting jurisdictional choices that are made for ships in order to have various forms of liability being missed, the airline industry is slightly different. So if you're flying on, for example, British Airways, you're technically flying on a British registered plane. So if, let's say, this is great, Agatha Christie, you're over international waters and you're in international airspace and there is a murder on the 747, then the rules and the laws of the UK would apply because you are on a British registered vessel plane. And similarly, if you're on a Delta flight, it would be the same thing as an American legal system being applied. Thus, if there's an oil spill from a plane crash, it would be largely domestic between the national government where the spill occurred and the national government that had flagged the airline. We don't have an environmental treaty for that yet, although you never know. When we get bored with other topics, we could certainly do that. But that would most likely be a joint effort between the ICAO and UNEP or whatever the other entity would be, because civil aviation is very different and it has a number of different restrictions in order to make it actually a viable industry. So there are all sorts of strange nuances from aviation law that we could get into that try to cap liability in order to keep us all able to fly.
I'm also, yes, yes. It's interesting. I'm going to skip ahead to a little bit, and this is because this question has been very hotly debated in the chat already. I think it'd be great to
Excellent.
hear. And there's really
Yeah.
no silly questions, by the way. There's
No, no,
no,
no.
this is
Oh no.
complicated stuff and very difficult stuff and also not very well known. So, as a person from India or just anywhere really, why
Mhm.
should I care about international treaties and laws? Why should I care about
Such a good question.
these? For example, I'm reading more about Indian laws and don't know international treaties. How would that make a difference in my climate work? What value would it add if I specifically learn about international law and treaties?
So this is a great question. I'm really glad that you asked it. I get asked this all the time by students, by would-be students, by legal practitioners who are domestic practitioners and look at me like I don't make sense. Um, First of all, there are several layers, but first of all, um, if you're in any state that is a signatory to any international environmental law or any international law, the laws that you are learning and the laws that you are applying and subject to come in part from those treaties. So when we think about, for example, the environmental laws that are in place in a country, so if you think about Indian environmental laws, many of them relating to climate come directly from obligations made under the UNFCCC and the Paris Agreement, the Kyoto Protocol, etc. And when we think about how the oceans are used, how coastal resources are used, whether or not there can be extractive drilling for oil or other natural resources off the coast. So in this example, because someone gave the example of India off the Indian coast, again, this is governed by the law of the sea, the convention law of the sea. And the decision making that is possible is made under the idea of the law of the sea and whether or not there can be drilling beyond certain point because that is not allowed under UN close or decisions are not allowed beyond certain geographical points. So much of the law that you know, whether you realize it or not, and much of the law that you study and also that you apply if you are in any type of practice, comes from international law. So that's reason number one. It's a really fundamental reason. The other reason is that international law, provided that the country you're in is a party to different treaties, will also provide potential ways for you to have remedies if there is a question that isn't properly addressed by your national government. Particularly in the human rights context, for example, a number of the human rights treaties. So this is just to answer the question really broadly for international law generally, create various types of complaint mechanisms. So if you are the family member of, for example, someone who has been held in prison and is you don't know where, you don't know whether they're alive, you don't know what their conditions are, what they're being charged with, etc. Um, and you try to get information at home and you get no answer, then you can have what becomes the grounds for a potential complaint at the international level, where you bring a complaint to one of the human rights bodies, the applicable human rights body, and they then have the ability to, if they find jurisdiction, to look into the matter and to provide some either information to you or request to the state that they actually provide you information, etc. So there are various means increasingly where individuals can use this as well, and also where community representatives, so whether you're representing an indigenous community, a community group, a civil society organization, etc., can also seek those types of avenues. So it's important to know what is there, as generally anyone who's practicing in any type of international setting or national setting, or even just knowing what rights are out there for you.
Yeah, yeah, awesome, awesome response as always. Um,
Oh,
there are questions over the precautionary principle legal status
yeah.
in international law and challenges with operationalizing the principle limit, its effectiveness for preventing environmental harm in practice. Could you share briefly about this?
Yes. So many treaties have the precautionary principle articulated as a principle for how the treaty is indeed intended to be applied, um, which is very important. Most of them do not because it is a principle. It is not a hard law obligation. Most of them don't have it as something that is a shall provision, shall use the precautionary principle. Thus, it is still considered to be soft law under most aspects of international law. However, many countries have had case law that comes from the principles that we saw in Rio, that comes from multiple treaty regimes, and that recognizes the precautionary approach or precautionary principle as a legally binding obligation under their jurisdiction. And certainly the EU, in the EU Court of Justice cases, Court of Human Rights cases, has highlighted that it is indeed considered to be a fundamental aspect, certainly of EU law, to include. So what we see here is kind of an explanation of why articulating the principles in a treaty that are intended to be applied to the treaty and its topic area at the international level is really important because it's a two-pronged approach. It's important internationally, so we can check, for example, national reporting, other instruments, nationally determined contributions, et cetera, to see how it's being applied. And then we also can give guidance to national courts, to national legislatures when they're trying to figure out actually applying treaty obligations and operations in terms of what principles should be used to interpret and what principles should also be used in their national legal systems. So certainly the precautionary approach is one of those, if that helps. Hopefully it does. If it doesn't, if any of these, you want to know more, either let us know or send a message and we're happy to talk more.
There are a lot of questions still, but I know
I
we're
know.
running to the 30. So
It's
let's,
works to the 30, and then we can always save them and talk about them next time too.
and
Because I
I,
don't want anyone's questions to be kind of overlooked. So we can do that or keep it for the extra session too. That's fine.
yes. So also what we'll do is we'll talk about Slack, WhatsApp. I know that there's been a
Yes.
lot of discussion
Yeah.
with the WhatsApp security recently, so we'll kind of look
Yeah.
into see what is the best option um to have discussion. So the last one, unfortunately, I think this will be the last one for today, is how did the world come out with the Rio Declaration? Is it through the UN General Assembly, through a separate process? And are the triple MEAs the outcome of the Rio Declaration?
So I think, how do I best go back all the way to the beginning? The UN Environment Assembly, as we know it today, did not exist at the time. There was UNEP and there was a UN General Assembly, and the combination thereof convened to give us the Rio Principles. So they've always been under the auspices of kind of the UN umbrella and the UN structure. Um, the same negotiating session in Rio that gave us the Rio Principles also gave us the three conventions. So this was one really, really big negotiating convention. Obviously, there had been groundwork laid for a long time in prior negotiating sessions, but the Rio session in 1992 was the one that gave us everything together. So yes, in a sense, you can say that the Rio Principles gave us the three treaties, or at least informed the three treaties because they were adopted at the same time. And much of the negotiations really kind of focused on incorporating the principles into all three of those treaties. And then from that point onwards, they have each kind of run with lives of their own, some to more visibility than others. The UNFCCC COP attracted 50,000 people last year. The Convention on Desertification and Drought did not. But there's also something to be said for that, right? The small COPs mainly pay attention more. So there's that. But they are all kind of inextricably kind of tied together. And then also the subsequent COP decisions really come back to those principles. And you see this time and time again.
Awesome. We actually might have time for one more question.
Okay, good. Excellent.
Yes. And I just saw a question about the polluter pay principle. We could
I
talk
know we're
about
going to come
that
back to that next time.
forever.
We'll
Yes.
come back to that next time, and we will also then talk about it when we get to the plastics treaty and the concept of both applying that and then maybe extended producer responsibility. But
So do you find it ironic that MEAs, which are supposed to tackle transboundary issues, are anchored on West horrible
Westphalian, yes.
Westphalian sovereignty?
I don't find it ironic. It is often frustrating because it does place a state-centric view. It is not ironic in the sense that this is the international system we have. The international system we have is based on state sovereignty for good or for ill. And, we could debate whether the Westphalian system is all forms of undemocratic or biased, etc. There are many debates we could have about it. I don't think it is ironic. I think it's actually highly emblematic of the way that international law works. Um, Yet there are many other areas that we could talk about. When state sovereignty, for example, should perhaps bend to the protection of human rights or the protection of environmental rights, etc. Um, but it's a great question. It's a really great question. It takes many of us back to our days of political science theory. There you go.
Guess one last question, because we kind of already
Hmm.
covered it, but the
Yeah.
BRS and Minamata conventions have on
Yes.
Mercury have COPs, correct?
Yes, they do. Essentially every certainly environmental treaty that we have has a COP. So BRS meets every 2 years and is meeting, or three are meeting, as I said, in April, as you saw that lovely session. Minamata also will be meeting later this year, in I believe October or November. No, it's November. It's November. Um, they don't rotate. They're always in Geneva. So we don't get the fun choices of like, where are we going this year? It's always Geneva, which is not a bad thing. We love Geneva,
Yes.
but the rotation isn't there. But yes, and they do function as all the other cops do. They are a decision-making body. They can adopt amendments. They can adopt annexes, make other decisions to guide the process, etc. Also give advice to and requirements to the Secretariat for its work program for the next 2 years. All of these things.
I think it's also worth mentioning that different COPs have, or treaties have different level of youth engagement. Some have
Yes.
more
Yeah.
than others. Plastics Treaty in particular has been known to have increasingly more youth engagement. So I think on that topic as well, it's worth pointing out.
It definitely is. And that doesn't mean, of course, that space couldn't be created if youth are particularly interested in BRS or in Minamata or anything else. But by having a presence in plastics from the beginning, it's a really great precedent.
Yes,
Be encouraged.
no, definitely. And I can also tell from talking to people that there are secretariats out there wishing for a lot more youth involvement
Yeah.
as well. So I think that's a good way to end it today. Thank
Mhm.
you. I'm going to stop recording now.